Well, we're hoping that the AGF will perhaps implement some of these suggestions. But when the judge says that, the rider to this lead story where he says, judges will no longer strike out or dismiss corruption-related cases for want of diligent prosecution, that's ascribed to the CJN. What does that mean? What kind of impact will it have?
Well, you see, as I said, if EFCC follows due process, there is no reason why they should strike out. But the first thing, because there is a defect in the way and manner cases, as I told you when we were young lawyers, any criminal charge based on information, they must first show prima facie that he has a case to answer. The way to do it is the judge will look at the charges and say, okay, I'm satisfied. But under the Lagos State Criminal Procedure Law 2011, that duty has been removed from the judge and handed over to the Attorney General. But all the FCC cases today that they take to the state high courts in Lagos, and they never send it to the DPP. And that is why when it gets there, the lawyer will raise a preliminary objection.
Wow.
But the CJ is saying, and now they will not be. But it must happen because there's you can't build something on nothing. The EFCC method is wrong. The police are still there today. That's what they do. But they are not part of this. The police have been trained. When they do investigation, they send it to the DPP's office. Then they act on that advice before going to court. EFCC does not act on any DPP's advice. In-house, they investigate. In-house, they prefer charges. In-house, they take you to court straight.
So that can't work.
Then the lawyers will see the defect and say, yeah, I am challenging, number one, you, EFCC, you are a federal government agency. You are using the Attorney General's fiat in a state to prosecute under state law. And you are saying Federal Republic of Nigeria versus so and so. Whereas under Section 174 of the Constitution, the Federal Attorney General cannot sue anybody except on laws created by the National Assembly. And you, EFCC, you are going before Lagos High Court under the fiat of the Attorney General of Lagos, and you are using the Federal Attorney General to sue under the Criminal Code.
What if the Lagos State Attorney General delegates his powers or gives himself special permission?
Then use his name. If I give you a power of attorney to use my name to do, then you can't use it. If you say Lagos State versus but go and look at all the charges. You see Federal Republic of Nigeria versus this. Whereas you are charging them under state laws. He hasn't got the power. A lawyer will see that he will object.
Okay.
Yeah, I'm just saying that, I'm sure that some of Mr. Clarke's colleagues this morning might not be very happy with your comment. Because if you look at the way that some of the cases have gone, would you say that largely it's been their fault that some of these cases have not progressed past where they are right now?
Look, it's a synergy of faults. Fault from the presidency, and fault in the judiciary, and fault in the investigation. It's a culmination. You cannot isolate one from the other. If there's no petrol in your car can't work. No matter, even if it's a new car. If one tire is down and you have a new car, you can't move. Everything must go together. That is what is lacking. Let us try, bring in DPPs, over 100 here. Within 6 months, I can assure you, all this backlog will go.
Speaking about conflicting judgments, explain this to us, because look at this matter about Abia, where you find one court gives another. What's going on?
You know, this is a very funny story you brought out. In yesterday's Sun at page 44, I was shocked to find the Federal High Court registry claiming to, give reasons for the so-called conflicting judgment. It has never happened in Nigeria, where judiciary will be making public statements to justify Number one, the fault has been with the Supreme Court in Amechi's case. And I've said it on this program. In Amechi's case, the Supreme Court erred, and I know they have now, kept away from it. You cannot say an electorate during voting time is voting for a party. Amechi never contested any election, and yet he became governor. Because the Supreme Court says it is the party you are voting for, which is not true. So under the Electoral Act, the party is a legal being. His duty is to recommend a candidate for election who is a human being. So the duty of a party, he cannot be the candidate. He can only recommend a candidate. And once he does that, it is the candidate that is being voted for. So what the Supreme Court should have done, the consequential order they issued in Amechi's case, was wrong. They could have annulled the election and asked for a fresh election. And that's the same mistake our bank is making. You see, pre-election matters can be heard by the Federal High Court. But who becomes a candidate and who is elected and who is announced is within the realms of the rights of INEC.
Which is a pre-election matter?
No, at election.
Okay, at election.
If in a pre-election matter you challenge the right of a candidate to have been elected, like in this Abia case, he said he brought forged certificates. Okay, the law says if the election tax return.
Yes, tax returns.
The law says that if you take him before the election to a high court, federal high court, and the election is held and is voted for, it does not disturb your rights. When you get to the Supreme Court, if you are correct, then that election will be nullified. But not for you now to direct, when you are not an election panel, that somebody should be sworn in. The right to declare a winner of an election is vested in INEC. So the consequential order should have been, you brought in forged certificates, you could not have been elected, the election is void, go and have another election. So now, what happened in Abia's case is so funny. You went to one judicial division of the Federal High Court, you got a judgment. Knowing fully well that that judgment is a valid judgment and has to be... Another person went to another court. Now the Federal Registry, High Court Registry, is now telling us that there's a difference between the two cases. The subject matter is the same, governorship of Abia State. The personality, the governor is the same in that candidate. Why not the rule of law? Why did the court in Port Harcourt or wherever they had gone out and, my learned brother in Abuja has just delivered the judgment in this case. Let it go to appeal. You are now saying that the documents he presented, there is presumption that it is correct. Whereas this court has said it is forged. The same Federal High Court. Where are we going? And I've always said it, we only find these problems in political cases. Since 1999, conflicting judgments have only arisen from political cases. All other areas of law have been settled in other matters, except politics, and it's because of corruption. Since 1999, 80% of cases going on appeal to Supreme Court are all election matters.
Wow. When
we have elections, the whole judiciary is closed down for 1 year. They give prominence to election matters. Directive from the CJ that every election matter must be given. So that you find today appeals of 2008, 2010 has not been heard by the Supreme Court.
Wow. All right, Mr. Clarke, a very illuminating perspective there from Mr. Robert Clarke, Senior Advocate of Nigeria. We always appreciate your comment on every
Thank you very much. Always my pleasure.